All right. Welcome, everyone. We're so pleased to have you joining us today. Good afternoon to those on the East Coast and good morning to those on the West Coast. Today, we're having a webinar on race-based grant-making and charitable activities, protected First Amendment speech or prohibited racial exclusion. This is a joint webinar presented by BakerHostetler and Fair Chance. My name is Alexander Reed. I'm the leader of BakerHostetler's tax-exempt organizations and charitable givings team. Today, I'm joined by Erica Thomas, who's a partner in our Washington, D.C. office. Erica is a litigator and speaks the language of the courts, so we're really delighted to have her help in explaining where things stand with the Fearless Fund litigation in the 11th Circuit and on other matters related to courts and litigation and all that happens in that world. Alex Campbell is counsel in our Cleveland office. He's my right arm and serves as outside general counsel to lots of public charities, private and community foundations, and other tax-exempt organizations. He's outstanding, and I'm really pleased to have him here with us at BakerHostetler. Gretchen Vanderveer, PhD, is the Chief Executive Officer of Fair Chance, which is a social change organization that strengthens community-based nonprofits to achieve life-changing results for communities impacted by racism, discrimination, and poverty. Gretchen's a specialist in education policy and is running this really wonderful and robust nonprofit organization here in Washington, D.C. Kristen Barney is the Network Services Manager for Fair Chance. She supports current and alumni partner organizations through 5 network service offerings, and she was previously the Impact Academy Program Manager and Capacity Building Specialist at the Racial Equity Task Force member with Fair Chance. So before we get started, I just wanted to run through a couple of housekeeping items so that we can get you your continuing legal education credits for those of you interested. This presentation will be approximately 1 hour and is approved for 1 hour of CLE credit in California, Colorado, Florida, Georgia, Illinois, New York, Ohio, Pennsylvania, and Texas. New Jersey credit is available via reciprocity. CLE credit may be available in other states upon request. In order to obtain CLE credit, this is very important, okay? There will be 2 separate codes that I will announce during the program. You'll need to write down these codes. At the end of the webinar, a survey will appear, and you'll need to answer all of the questions and include your bar number and state. So make sure to get your bar number and state and write down those codes when they appear. If you have any questions during the presentation, click on the Q&A button and type your question. We'll try our best to answer them at the end of the program, time permitting. If not, we'll follow up with you after the webinar to answer your question. A recording of the webinar, the presentation materials, and presenter contact information will be provided in a follow-up email. Before we get started, we want to take a quick poll to see who we have in attendance, since this topic is relevant to so many for different professional backgrounds. So please let us know where you're coming from. Can we do that poll? Go ahead and type it into the chat if you'd like to. There we go. Here's the poll question. What type of organization do you work at? Individual, academic, collaborative, community-based, grassroots organization, consulting firm, corporation, corporate foundation, government, intermediary, capacity building organization, legal firm, legal clinic. Thank you for completing that poll. And let's dive right in. Very good. Oh, let's see. Let's actually go ahead and put those results back up. That's interesting to see. It looked like the largest number were from the foundation space, so that's great. All right. So Gretchen, why don't you give us a brief overview of Fair Chance?
Happy to, Alex. Thank you so much. Fair Chance is thrilled to see so many of our colleagues from the nonprofit and foundation sectors with us today, as well as the rest of you, and to be co-sponsoring this webinar with BakerHostetler. A timely analysis of the potential implications of the Fearless Fund case is important for all of us in the social sector, and particularly for those of us with race-conscious programming and a commitment to racial justice. The slide on the screen shows how Fair Chance works through a pipeline and cycle rooted in local contexts. Since 2002, we have been strengthening community-based nonprofits in communities impacted by racism, discrimination, and poverty. And we do that through a variety of partnerships, programs, and services built on trusting relationships, addressing racial equity gaps, and ensuring better outcomes for children, youth, and families. Our advocacy mobilizes nonprofit workers to address unfair policies, such as the limiting of indirect cost rates on grants and contracts. Our network services encourage collaboration across geography and issue areas, such as this webinar, and an upcoming event we have on May 20th called the Roundtable, which brings together nonprofit and community leaders and funders to discuss topics of common interest. And if anyone on this webinar is interested in participating, please put your contact information in the chat and we'll send you an invite. Our capacity building centers on the needs and interests of local leaders and leads to more sustainable organizations that double their revenue and the number of children, youth, and families they serve. In 2023 alone, we worked with 100 nonprofits who in turn impacted the lives of 14,000 children. Our capacity building programs serve primarily leaders of color, which helps us achieve one of our bold 10-year goals to close the revenue gap between white and people of color-led organizations. In addition, many of the nonprofits and funders we work and collaborate with provide services or funding specifically for race-conscious programming. So when Kristen Barney, Fair Chance's network services manager, reached out to BakerHostetler and found them eager to co-develop this webinar, we were thrilled. And our board member, Sonia Williams-Murphy, an attorney with the Justice Department and the chair of our Racial Equity Committee, was also instrumental. And I want to thank her, Kristen, and the rest of the Fair Chance team for making this happen. And I got to say, the attorneys at BakerHostetler have been terrific to work with. And I want to thank Erica, Alex, Lindsay, and Madison for your efforts leading up to today. But most of all, I want to thank you all for being here and leaning into this issue. I look forward to learning with all of you more about how the law is on the side of race-conscious policies and how nonprofits and philanthropies can be most intentional about achieving missions focused on racial equity and redressing past injustices. And with that, I will pass it on to Alex Campbell.
Fantastic. So Alex, why don't you tell us a little bit about the definition of charitable under the tax law and how race plays a role in that definition?
Thanks, Gretchen. Thanks, Alex. A little level setting here about what the laws actually say on the issues that we're talking about today. So you may all be familiar with Section 501 of the Internal Revenue Code. So Section 501A says that an organization that is described in Section 501c3 is exempt from income taxation. Section 501c3, which many of the organizations represented, individuals and organizations represented among our many attendees are affiliated with, says that an organization has to be organized and operated exclusively for one of several specific purposes, including charitable. The organization has to be organized and operated exclusively for a charitable purpose. Also has to primarily serve the public rather than private interests. Treasury has told us, what does charitable mean? Treasury says in part that it is used in its generally legally accepted sense, not super helpful, but lists specific examples of what is charitable. The relief of the poor, advancement of religion, advancement of education, but these ones at the bottom of the slide here, the promotion of social welfare for organizations to accomplish any of the above purposes or to lessen neighborhood tensions, to eliminate prejudice and discrimination, to defend human and civil rights. So that baked right into the statute, baked right into the Treasury regulations is race-conscious activities. Next slide, please. And so race and racial issues have long been explicitly recognized in connection with and as charitable activities. You can see here several revenue rulings from the Internal Revenue Service over, particularly in the 60s and 70s, but recognizing organizations as charitable organizations involved in housing discrimination issues, employment discrimination issues, purchasing of housing, rental housing. You can see one in the late 70s, actually a job training program exclusively for one particular ethnic minority. Next slide, please. We've also seen organizations recognized as exempt over the years that use economic conditions, which can be, in some cases, a proxy for race. So organizations that provide financial assistance and loans to organizations and businesses and individuals in economically depressed areas, organizations that lessen neighborhood tensions, again, one of those specific charitable purposes, by providing funding to organizations to fight poverty and community deterioration. And these are, again, 60s and 70s, but also more recent. So this isn't just, this is what the law used to be. This is what the law is today, that organizations engaged in race-based activities are considered charitable. You can also see other examples such as public interest law firms and economic development organizations, many of which use economic conditions, in some cases explicitly race, in some cases implicitly race, in defining the charitable class, meaning the individuals and organizations that organization serves as a part of its charitable purpose. Next slide, please. One of the other requirements of an organization to be a 501c3 is that it is not in, does not violate, the activities do not violate public policy. And so we've seen a little bit of dissonance in some of the Treasury and IRS examples over the years. There are organizations and trusts, funding organizations, direct service organizations that have been recognized as exempt, even though they explicitly, I mean, on their face, explicitly support exclusively minorities. We've also seen trusts, for example, that have been disapproved as violative of public policy. For one example here, exclusively serving worthy and deserving white persons. And so there is a question, among practitioners and others, where do we take this? And that's what we're talking about today. Does it matter if are we remedying past discrimination? Are we remedying current discrimination? What is charitable about using race implicitly or explicitly in our charitable activities? Next slide, please. And then one more example of race in the context of charitable activity is specifically for private foundations. Alex showed us the results of the poll, which showed a significant number of private foundations and community foundations represented among our among our attendees, which is great. And there is a requirement that a private foundation, specifically a private foundation, any grant to an individual must be awarded on an objective and non-discriminatory basis. But actually the regulations, again, look directly at what Treasury is telling us. There's an example of a private foundation scholarship program. This is an approved scholarship program, or IRS is telling us this would be an approved scholarship program, which is specifically, explicitly reserved for members of an ethnic minority. And the IRS has recently affirmed this position. So again, not just in the regulations, but this is still the state of the law, with a relatively recent approved program this year approving a scholarship program that, among other things, provides funding to students from historically underrepresented groups that includes college-bound minority student candidates. And so one of the things we'll talk about is what is the impact of the Supreme Court opinion from last summer on affirmative action? What is the impact of the Fearless Fund in litigation on the activities of race-conscious philanthropists, race-conscious organizations, race-based scholarship programs, Black-owned business programs, things like that. So we're happy that you're all here, and we're happy to dive right into this issue. Next slide, and hand it over to Kristen.
Thank you, Alex. So in order to understand the current landscape and the ongoing litigation around the issue of race-based grant making and charitable activities, we will be discussing the Fearless Fund litigation. So what is the Fearless Fund? The Fearless Fund invests in women of color-led businesses. It was launched in 2018 with a mission of bridging the gap in venture capital funding for women of color founders who are building scalable, growth-aggressive companies. According to studies by the Fearless Fund, cited by the Fearless Fund, in 2018, U.S. companies raised a total of $130 billion in venture capital funding, yet only 2.2% of that total went toward female-founded companies, and less than 1% of the total funding was allocated toward businesses founded by women of color. Fearless Fund was established to address this very gap in venture capital funding for women of color-led businesses, and in their own words, to finally push the needle on the abysmal statistics that drive the current narrative for women of color-led businesses today. The Fearless Fund team also established the Fearless Foundation, a 501c3 organization that provides capital, community, mentorship, and education to women of color entrepreneurs. And it is one of the Fearless Foundation's grant programs that has been challenged in litigation. Specifically, the Fearless Strivers Grant Contest is a skills-based contest that awards winners with $20,000 grants, digital tools to help their businesses online, and supportive mentorship. The contest is open to Black women small business owners only. The plaintiff, the American Alliance for Equal Rights, describes itself as a not-for-profit 501c3 membership organization dedicated to challenging distinctions and preferences made on the basis of race and ethnicity. The Alliance claims that it has members who are otherwise eligible for the Fearless Strivers Grant, but cannot apply because they are not Black women. Accordingly, they have sued the Fearless Fund, Fearless Foundation, and related entities, and are alleging violation of anti-discrimination laws. The lawsuit has garnered the attention of nonprofits and many other sectors who are concerned about the future of race-based grant-making and charitable activities. And now we will hear more about this case from Erica Thomas, partner at BakerHostetler. Erica.
Thanks, Kristen. Thank you. Oh, I see it. I see a CLE code
Yes,
there.
you do. Yes, you do.
Please take note of it.
Please take note of the CLE code, which is capital G Grantmaking 2024. I don't know if it's case sensitive, but just in case it is, please capitalize the G. Grantmaking 2024 is your first CLE code. Thank you very much, Erica. Back to you.
Thank you. So I'm a litigator, so I have to give the caveat that I will be talking about these very complex cases in a very high-level summary way. We thought that would be helpful. We think it will be helpful, especially for participants in this webinar who are not lawyers and who may not be familiar with the legal terms and just the status of the pleadings and the import of these cases. I will say all of the legal arguments are online. You could even listen to the appellate arguments if you were so inclined. Very interesting. So as background and context for talking about the Fearless Fund litigation, we have to talk about this case, which is top of mind for many people, and it will likely have implications, even though this is not in the charitable space. So it's actually two cases. SFFA, Students for Fair Admissions, filed suit in 2014 against both Harvard and the University of North Carolina. Edward Bloom, who's the founder of the American Alliance, also is the founder of SFFA. But the claim was that Harvard and UNC violated the 14th Amendment of the Equal Protection Clause and Title VI of the Civil Rights Act of 1964 with their admissions processes by intentionally discriminating against Asian American applicants, by admitting Asian American applicants with higher academic scores at lower rates than other racial groups. The case actually went to trial in district court in Massachusetts and in North Carolina, and SFFA lost in both cases. These were bench trials. The SFFA appealed to the circuit courts in the Fourth Circuit and in the First Circuit. And in the First Circuit Court of Appeals, there was a decision in favor of the universities. So again, SFFA lost because the reality is that the universities' programs did comport with the state of the law at that time, and I'll say last June. In other words, their admissions programs considered race as one factor among many other factors in their holistic application process and the individualized consideration of applicants. All of that being said, in June, on this date, June 29, 2023, the Supreme Court actually reversed the lower courts and found that the consideration of race as a factor in the admissions process is unconstitutional. It's prohibited, even as one of many factors. Next slide, please. For several reasons, which are stated here, the court found that the universities did not show their compelling interest in a measurable way. Again, this is the dissonance that Alex Campbell was mentioning, because the university's programs did comport with prior case law on affirmative action in admissions, Grutter v. Bollinger and California v. Bakke. But the educational benefits that the university, that Harvard and UNC pointed to, a diverse student body, training future leaders, promoting the robust exchange of ideas, et cetera, were found to be not measurable and not valid reasons. The Supreme Court in SFFA also said that the universities failed to avoid racial stereotyping and that they used race not as a plus factor, but with respect to certain applicants as a negative or exclusionary factor, specifically referring to the Asian American applicants. And also the criticism was that there was no end point, which relates back to in the Grutter decision, there was an indication that perhaps in 25 years, these types of programs will no longer be necessary. So for various reasons, that decision did not explicitly overrule the prior affirmative action cases, but for all intents and purposes, and according to at least some of the justices, it did. So at least leaves some confusion in that area. How does this apply to charitable organizations? Well, in the strictly technical sense, it does not. This decision is in the context of higher education organizations' use of race in connection with their admissions criteria. However, in a very practical sense and a real sense, it does apply because the Supreme Court has shown how it will interpret the Equal Protection Clause of the 14th Amendment. It has shown how it will interpret Title VI of the Civil Rights Act. And these are strong indications of how it will interpret and enforce other anti-discrimination laws, such as Title VII in the employment context, or Section 1981, which is the statute at issue in the Fearless Fund case. So next slide, please. Now, the American Alliance, as Kristen mentioned, is another Bloom organization, which filed suit last August against various Fearless Fund entities. Their claim is that the Fearless Drivers Grant Program is a racially discriminatory program, that it is a contract by its own terms. Incidentally, or not incidentally, after that lawsuit was filed, Fearless Fund did go and revise a lot of the language in the program website to try to remedy some of those issues with finding that it was a contract. But in any event, American Alliance argues that it's a contract and that it discriminates against its members, who are 3 business owners who have suffered irreparable harm by their inability to apply for this grant program. You can go to slide 15, the next slide. I thought it would be very useful and interesting for everyone to see the text of the statute that we're talking about. The bold is not in the actual text. That is my highlighting, and that's what's cited in much of the briefing. So I'll just read that. All persons shall have the same right to make and enforce contracts as is enjoyed by white citizens. You might imagine, or you might be surprised to know that most U.S. statutes, even anti-discrimination statutes, don't specifically reference the rights of white citizens as the benchmark for the rights that everyone should have. So this statute does, and this 42 U.S. Code 1981 was originally the Civil Rights Act of 1886. It passed shortly after the 13th Amendment and was intended to give some force and effect to the rights that newly freed, formerly enslaved people were entitled to. It is deep. So it's just interesting to see, again, how this statute is being weaponized in an entirely different way from its intent. So we can go to slide 16. So this is the procedural history where we are right now in the context of the Fearless Fund case. You can see all of the briefing that has happened, the arguments that have happened. And I put this just to say, this is still at a very preliminary stage of the case. There has been no trial, there's been no fact finding or discovery, but right now the Fearless Fund grant program, or the Fearless Strivers grant program, is prevented because of the preliminary injunction that's in place from closing its application window or from awarding any grants. We can go to the next slide, 17. So this is where we are now, whether the Alliance is entitled to a preliminary injunction which they have in place right now and which is being appealed, is a very extraordinary remedy. The district court denied their request for a preliminary injunction. And to explain it in the most basic terms, if I sue you, I file a lawsuit against you, and I say I want the judge to stop you from engaging in some kind of harmful conduct, not only do I want that as part of my relief, I want the judge to do it now, before I have even won my case. That's the status of a preliminary injunction. The Alliance claimed that their members were irreparably harmed, and this is the standard that they had to meet. The district court found that they did not have a substantial likelihood of success on the merits, meaning you're not likely to win your case. The district court found that there was the charitable mission aspect, which would be protected by the First Amendment. The Fearless Fund's arguments are very comprehensive. There are many arguments that the Fearless Fund has mustered with respect to the lack of standing of the Alliance. They have only unnamed, unidentified alleged members who are called Owner A, Owner B, Owner C. The lack of harm to them, the lack of any harm, much less irreparable harm, the First Amendment issues for protection for expressive activity, also the public interest in private entities being able to make charitable donations, and the public interest in improving the conditions of economically disadvantaged groups. The district court denied the injunction that Alliance sought based on this standard. The American Alliance appealed to the 11th Circuit and on an emergency basis, and then got a reversal of the district court. And then their appeal of that decision was heard by a different panel on January 31st. And I think we could go to, do we have a next slide? Go back to the prior slide. Where we are now is we're just waiting. The last bullet. We're just waiting. A decision is pending. But the 11th Circuit has found that there is a strong likelihood of the alliance prevailing on the merits, because they say that, yes, 1981 prohibits discriminatory contracting, and this is a contract, the grant program, and that it is discriminatory. So that's where we stand. We're waiting to see what is the decision of the merits panel of the 11th Circuit Court of Appeals on that issue.
Fantastic, Erica. That was great. That was really helpful. It's going to be interesting to see what the 11th Circuit does, what that small panel does, whether an en banc rehearing of the decision, how that would play out.
Yeah, I would just like to say, one would hope that the makeup of a court should not matter, and by the makeup I mean who appointed the judges. But I will just point out that fully half of the judges on the 11th Circuit Court of Appeal were appointed by Trump. So even in an en banc setting, which we can believe that no matter what, the alliance will keep appealing to the next level. And that is what it is.
Interesting. And it's in some ways difficult to predict, even with that bit of knowledge about the appointment of the judges, where it will go. Will it go more in a libertarian way, or will it go more in a equal protection kind of way?
Well,
So
the First Amendment, what you're getting to, will be really, I think, the decisive issue, the application of the First Amendment, whether this is pure speech, whether it's expressive conduct, or what, because I think that's going to rule the day. Yeah,
exactly. So, there are a few ways of going about this. Lawyers love to parse and parse and parse till an issue is down to the smallest little nugget, and then analyze that nugget. And if you look at it from that perspective, you can distinguish lots of other precedents. You can distinguish the education precedent and the Harvard and UNC decisions as saying, look, those only apply to admission. They don't even apply to the entire educational matriculation process, right? You can use race in recruiting your students to apply. The decision doesn't apply to that. You can use race after you've admitted students. You can use race to recruit them to matriculate. The decision doesn't apply to that. It only applies to that middle step of the application process where you admit. And even there, race can kind of be part of a larger picture of a description of that student's experience and why their application is meritorious. So we can distinguish that whole set of cases from the Fearless Fund program and say, well, this program isn't really about matriculating to a university. It's not about getting the benefits of education. It's not about the long legacy of racism in higher education, where schools were segregated and charities making grants have a different history to them, and they're just birds of a different feather from educational institutions. So none of that precedent applies. That's one way of looking at it. Another way of looking at it is, Section 1981 only applies to contracts, and scholarships and grants are not contracts. So what's a contract? A contract is, I pay you and you render services to me, or you render services to a third party. There's government contracts, there's an employment kind of relationship, and using race in a private context involving employment may be prohibited, but that says nothing about grants and scholarships and charitable activity. So you could distinguish it on that basis. And maybe that's enough of an answer for those of you who have race-based programs in your charitable activities, and you're concerned about whether they're going to be challenged in the future. Maybe it's enough to say, well, I'm not a school, and I'm awarding grants not for employment purposes, and I'm not a government contractor, and I don't take any money from the government at all, and so these precedents don't apply to me. But in a larger sense, what this is really about is this kind of battle between private activity in furtherance of the public good, which is what charities do, right? It's private activity in the public good, and government, which is public activity for the public good. Which of those has precedent, and how much control can or should the government exercise over private institutions pursuing the public good? That's where the First Amendment kind of comes in. First Amendment, freedom of speech, freedom of assembly, freedom of the press, freedom of religion, and a penumbral freedom, or I like to say a prenumbral freedom, because I think the freedom of association actually underpins these freedoms that are enumerated in the First Amendment rather than derives from them. The freedom of association, the freedom to build an institution that reflects your identity and informs the way that you express your First Amendment freedoms. That freedom of association was first recognized in 1954 in the NAACP, the Alabama case, but recently was elevated from a reasonable basis scrutiny to exacting scrutiny, which is not quite as high as strict scrutiny. Strict scrutiny is what we apply to race, but exacting scrutiny is considerably higher than reasonable basis. And it's the case Americans for Prosperity Foundation v. Bonta. It's the one that says that states don't have, it's unreasonable for the state of California, for example, to request all of the Schedule Bs of every organization that solicits charitable contributions in the state of California. The Schedule B is where you list your donors. So, California's ability to demand that information was not viewed as having a substantial relation to a sufficiently important government interest, and wasn't narrowly tailored enough to achieve that interest. So, you can apply that exacting scrutiny to other restraints on nonprofit activity, and perhaps they protect it. But what's interesting is there's kind of an ironic flip here, which is that in the 60s and 70s and 80s, when these finally got to court, a lot of organizations that were segregated and had discriminatory policies argued that their First Amendment freedoms protected them from government efforts to integrate their programs. They said, because of our biblical teaching about the separation of races, we don't want to admit people of different races to our programs. And the courts at that time said, well, sorry, your expressive freedoms don't trump the government's interest in preventing racism and segregation. And so they lost those cases, but here the shoe's on the other foot in some ways, and we might see additional protections to organizations to protect their express charitable activity as First Amendment protected activity. So that's kind of a prognostication about how things could go, whether the First Amendment does protect this type of activity. Let's go to the next slide. I think we're going to go toward a panel discussion here. What does this mean for nonprofits and funders engaged in race-based service activities and race-conscious philanthropy? Let's see. I'd like to kind of open that up. Any comments from what we've heard thus far? Alex, do you want to say something?
I did. So I just saw a question from the chat and now I'm trying to find it, but it was basically, is there a difference between the way that a grant would be treated and the way that other kinds of,
Yeah.
is a certain kind of funding mechanism better protected against a claim of discrimination under 1981 or otherwise than others?
That's a great question. It's a very interesting one. You know, in a lot of ways, a grant isn't a thing. I tell this a lot to clients. You know, a grant can be a unilateral contract. It can be a gift. It can be a contract for services. It can be a multi-year joint venture. It can be almost anything. If you put the word grant at the top, almost any contractual arrangement or legal arrangement can be a grant. Almost any programmatic activity can be a grant. So, you know, as a matter of substance rather than form, right? You know, you might say that if there's a quid pro quo where the recipient of the funds is required to do something in return for receiving those funds, you know, then it's a contract. That would be a broad description. And if it's a contract, then it's subject to the Civil Rights Act. And if it's subject to the Civil Rights Act, then these precedents where the Civil Rights Act was used to prevent discrimination could be used in this context to prevent race-based grant-making programs.
So a related question, this one's for me. There's a theory of a case to be made that recognition of exemption as a 501c3 organization is effectively a subsidy from the government. You're not having to pay, you don't have to pay tax because we agree that what you're doing is for the public good, as you said, Alex, private organization doing a public, serving the public good. Does that 501c3 status being conferred by the federal government put a 501c3 organization in any kind of precarious position for what we're talking about? Or has that argument at least been floated in any of the litigation that you're seeing?
I think that's also a very interesting question. You know, it's at the absolute core of what we do as you know, in the nonprofit space is 501c3 and the charitable deduction. So 501c3 exempts the corporate income of the entity from corporate taxation, and 170 exempts the contributions to fund that organization from the donor's income tax. Are those provisions subsidies of the federal government because the donor pays less federal tax than they would if they didn't make the gift and there were no deduction, and the exempt organization pays less tax to the federal government than it would if it were not exempt? So in one sense, you know, it could be viewed as a subsidy. It's certainly a benefit. It is an economic benefit to be recognized as exempt and to be recognized as having a deduction. There's, you know, in another sense, however, it isn't. In another sense, the deduction and the exemption from tax enable private individuals to pursue the public good without the interference of federal taxation. And so if there were taxation of nonprofits, and if there were no deduction for gifts to nonprofits, then the federal government would be taking a piece out of that support going to fund private pursuit of the public good, which arguably is, you know, unconstitutional, violates the Bill of Rights. There's been some litigation recently, the question about whether Title IX applies to private schools, independent schools. And the Fourth Circuit at the end of March just held that tax exemption of an independent school is not a subsidy that would cause that school to be subject to Title IX. So at least for Title IX purposes, tax exemption is not a subsidy. But the Supreme Court in Taxation with Representation of Washington v. Regan held that it is constitutional to censor the lobbying speech, the legislative speech and political speech of 501c3s because the federal government is subsidizing those activities, and there's no obligation by the federal government when subsidizing charitable activity to enable the subsidized party to use that money for lobbying or political activity. So it's right at the heart of what we're doing here with civil society and nonprofits and their relationship to governments.
Thank you. So I've gotten a couple variations on the same question, and I'll kick this to everybody, including our Fair Chance colleagues. So what are we seeing? What are organizations doing, specifically doing in response to the Supreme Court case from last summer and the pending Fearless Fund litigation and the, let's say, culture of fear that has been created from some of the cease and desist letters and other similar kinds of communications that some of our funders and others have received in light of those two and other pending litigation? Anyone is free to join and jump in. And what are we as lawyers telling our clients for a fair chance? What are you guys talking about? What are your board members thinking about? Erica, anything you're thinking about from your perspective would be welcome.
Based on what I've read, I do think that the mission of the organization, I think the First Amendment piece is going to be the most important thing, whether or not you're engaged in some activity that's expressive of your organization's mission. It may require some, rewriting of the mission statements. It may require some rewording of, as the Fearless Fund did, in the midst of the litigation, rewording of the grant application process and that sort of thing. But there are cases, I don't want to state it the wrong way, but there are cases. 303 Creative is a case out of Colorado in which the First Amendment right to expression does in a way trump anti-discrimination laws. That was a case about a website creator who didn't want to have to create wedding sites for LGBTQ people. It's just again this dissonance, Alex Campbell. You can use the same arguments, but it depends on what is the side that you're on, who's the court, who's the audience that you're directed to. But 303 Creative did say that it would be violating this creative person's freedom of expression to require her to make the websites for LGBTQ people. So it's that sort of thing. I do think the First Amendment piece is going to be, and that's been a lot of the argument on the preliminary injunction issues in Fearless have been around the First Amendment. Is this speech or is this just conduct? That sort of thing. So that's where I would think. There are just a couple of questions. There's a question that came up about the 11th Circuit. It's Alabama, Florida, and Georgia. So it is considered to be one of the more conservative circuits, but those are the states that are part of the 11th Circuit. And Section 1981, although it was created initially to clearly apply to newly freed, formerly enslaved people, there is case law that says it applies to white people as well. And it hasn't been amended to take out that reference to white citizens, but clearly the remedial concept, is still there, but it does apply to everyone.
Just oh, go ahead, Kristen. Did you want to say something?
Yes, I wanted to share about what nonprofits and foundations can do. There was recently a webinar by the Decolonizing Wealth Project, and I just put their website in the chat box. One of the things they said, their legal expert said, is don't assume you can't do racial equity in philanthropy or with nonprofits. There are ways that you can do it that actually deepen your commitment to racial justice. Specifically, racial justice needs to be embedded in missions and values. If repair and reparation and redress are in the mission, then racial conscious programming and policies can be defended legally more easily. And so I just want to share briefly what we do at Fair Chance. Our capacity building approach is very customized, very responsive to what's going on. And so we are going to be looking to partner with pro bono legal counsel and the community-based organizations that we work with to look at the missions and figure out, because every case is very, very different, that, you know, how can you achieve your mission? How can you frame your mission so that it actually speaks directly to what the law states? And of course, changing a mission isn't just about changing the words on your website. A mission is related to your strategy, and so and everything that you do. So combining capacity building, consulting, support on strategy and management with legal advice can be a really powerful combination for this situation to blend those two supports.
That's great. That's a helpful way of thinking about it and framing it. And, you know, I think I agree that there's maybe some ways to make lemonade out of out of lemons, you know, because what the Supreme Court is saying is, you know, we don't want vague notions of how race helps. We want, you know, we want measurable outcomes and, you know, something, and we don't want it to be used as a negative. And so, you know, that's kind of a worthy challenge in a lot of ways to say, well, okay, what exactly am I trying to achieve by using race in my programs, and how do I know if I've achieved it? You know, if you can measure it, then it's you know, likely to have staying power and you know, perhaps some other positive external benefits. So I agree that it's not the lesson. The takeaway should not be don't do it, or, you know, it creates legal risk to have race involved in your philanthropic programs. But the challenge to think about it deeply and really integrate it into your programs is worthy.
So
Also,
Gretchen,
I was going to say it sounds daunting, but we talked about this a little in our pre-call. Again, as a litigator, you always hear, let your opponent make their case. You don't want to just decide in advance of anything specifically happening to just pull up stakes and abandon your programs. You have to use the resources that are available to be prepared. And then, but again, don't make any hasty decisions to retreat from programming if you can try to manage the program, you know, in accordance with applicable laws.
yeah, and that's why we started with the legal basis. What is charity? I mean, charity, again, baked right into that statute and those regulations is the kinds of explicitly race-based
Right.
that we're talking about. And so if there's a takeaway and a thesis, it is to lean into this. If this is something that's important to your organization, don't let the Supreme Court opinion from last summer or Fearless Fund litigation distract or detract from the work that you're doing, but be informed. Pay attention to what the changing legal landscape is. I mean, it is changing. There's no question. There are new threat vectors that didn't exist, or at least weren't as explicitly in the open as they were even a year ago. But we hope this is helpful and kind of gird the work that you're doing.
And I just wanted to add thanks to this panel. Great comments and resources, particularly the one from Decolonizing Wealth. And I just want to say, everybody, don't be afraid to have conversations with your board about this. Now is the time, and I can tell you that our board has had really good conversations. And again, we all need to be aware and really clear about who we are and what we do and for what reason. So it's a great opportunity to check in on that.
And we've gotten
Lots of good questions in the chat, though, if we can get
we
to
really,
it more.
really appreciate the questions. Housekeeping note that Alex Reed was probably just about to do, because we've gotten this question several times. We will be providing a copy of the slides, also a copy of the recording from the presentation, and the contact information for all of us panelists.
Yes, and let me actually just jump in and give the second CLE code. Really mundane. Sorry, we're right in the middle of exciting stuff, and I'm going to give you a CLE code. It is charitable, capital C, charitable 2024. Capital C, charitable 2024 is our second CLE code. So that you'll only need those two codes to type into the survey at the end to get your CLE credit. Some states, I think New York in particular, requires us to be sure that you really were here. Let's go back to those. You can leave the code up there for a minute. Alex, was there another question you wanted to pull out to talk about?
I've gotten a couple different variations on the question. Basically, this sort of gift versus contract, grant versus contract dichotomy. And I think what we're saying, Alex, and
yeah,
you think otherwise, is that that's not really yes, there is potentially an argument, a stronger argument to be made regarding a 1981 challenge if it's considered a contract. But
correct.
We're almost taking a step further back from that, which is, remember what we talked about at the beginning, which is that remedying racial discrimination is considered a charitable purpose. And so even if one is engaging in a contract in furtherance of that charitable purpose, that could be a defensible position.
Yes, that's right. We definitely don't want to lose sight of the fact that even if it's a contract, it can still be charitable and defensible. The question of what is a contract is very interesting. Many weeks of law school are devoted to this topic, and it's a hard question. You know, if I promise to give you a gift, is that a contract? Can you tell me, you better pay up, you promised? And the answer is, well, it kind of depends. If I promise to make you a gift and then you take steps based on that expectation that you were going to get the gift, like you start building a new building on campus, and then I don't pay up, yeah, that might be an enforceable contract that you can go to court and say you better pay up. That's the question of enforceable pledges that we see in a lot of different contexts. You know, if I say I will pay you to stop smoking cigarettes, I'll make a gift to you if you stop smoking cigarettes. Well, maybe that's a contract because there's some specific performance required by you to to get the gift. You have to stop smoking cigarettes. So these cases are kind of intellectually fun to think about in terms of what is a contract and what is not. But don't lose sight of the larger point that even if it is a contract and it is race-based, there's still a lot to be said for protecting it, and it's not. We're not going to lose it.
Great, thanks very much. I think we're at just about time, so if we can take down this slide and get any last thoughts from our panelists, and Alex, if there's any other housekeeping notes we have to do.
Yeah, I think we are. At the, we've done more than scratch the surface. I think it's a deep and very interesting issue. There's going to be a lot more to say about it in the coming years. We're so grateful that you've been here to share this with us today, and I want to thank our panelists for their very thoughtful comments and preparation. It was really, really helpful. We're grateful to you, our audience, for all the great work that you do. It's important, and let us know if you have questions about this or any other topic. We're all kind of mission-driven people here, trying to make the world a better place. So thank you for all that you do.
And I just want to add with a comment in the chat, so important to lean in and not run, and be strong in your mission to eradicate injustice, racial injustice in this world. Thank you. Thank you for all you do.
And I just wanted to ask, I know you didn't do this just to get new business, but if people are interested in consulting with BakerHostetler on these issues, who should they reach out to, and what do you offer?
Well, thank you for asking. That's very kind of you. So you can reach out to any of us, of course, on the panel. And we Alex and I are happy to help you. We have a good team here, and we're a full service law firm. So if you need litigation, Erica is here to help you with that. If you need corporate governance, Alex and I can do that, and our partner Matt Elkin and Ed Beckwith and a number of others have a lot of experience with that. Tax advice, disputes with IRS and other regulators. We do all of that. We also do, regulatory and policy advice. If you need systemic
And a big part
advocacy.
of litigation is pre-litigation, avoiding litigation. So
That's true. That's true.
Well, again, we are so grateful. Thank you to you and for everyone that was here today.
And we will continue to follow this and continue to do presentations like this if needed.
Yeah. Thank you. So Lindsay and our team, we're going to turn it over so so our participants can get their CLE credit now. But thanks again, and we'll see you all later. All righty.
Bye, everyone.
Thank
Have a
you.
great week.
Bye, everyone.